How do you react when the person doesn't respond? Like if you want someone to empathize with you, but they don't, how do you feel? Mm-hmm. How do you feel?
When they want to quarrel with me, I just keep silent.
You keep silent, right? Shut down, or maybe get angry. So again, we're trying to think about like what's the process and what do we want, right? Because when we talk about conflict resolution, intellectually we can think, oh yeah, I want people to empathize and understand, and So that's the first part. And then we talk about 4 strategies. We'll get into 5 strategies later, but so what we do is we look at what's interesting about these strategies. We just did negotiation skills yesterday, right? So these strategies actually relate also to negotiation styles, which is interesting. But so this is just a matching. The students match competition. Competition is like a hard negotiator, so trying to win. Accommodation is like a soft negotiator. It's like, okay, yeah. A person who's accommodating, that's A, satisfy their concerns while reject. So that's like a soft negotiator, very similar. Even though we're talking about conflict, now we're talking about if we want to connect it. Avoidance is, be silent, right? It's like, I don't want to deal with it. So that's D, not paying attention. And then collaboration is more like a principled negotiator, which is cooperating, working together, okay? So we look at this, and then we have these animals here, and I'm going to ask you, which animal, what do you think the animals represent? Let's talk about competition. Which animal represents competition, do you think? Lion. Yeah, competition. What about accommodation? Which one? Oh, let's go to avoidance. Let's go to avoidance first. Avoidance. Which one is avoidance? The tortoise, because the tortoise goes inside the shell, right? So avoidance is the tortoise. Collaboration is the dolphin. So we see 2 of them there together. And so zebra would be accommodation. The idea with a zebra is it sort of blends in with the environment, right? So accommodating. And then the students discuss which animal represents you, right? What do you think you are? What animal? What do you think represents you when there's
Sometimes this,
What's that?
sometimes dolphin, sometimes lion, sometimes zebra, so missing.
So you have different styles, right? Anybody else? So maybe depending on the situation, right? Sometimes you may.
And we try to know what the partner wants.
Right.
Okay? So that we should have the good negotiation. So that to both, right?
Right.
Both party get and expect for the future.
No, that's good. So the dolphins are great because they collaborate. They work together to solve problems. Good. Okay, so we kind of want the students to sort of think about this, like, what are you, but what do you think is the best, right? And if there's conflict, right, going into a shell maybe isn't a way to resolve it, right? But maybe there are situations where you do that. So we're getting students kind of thinking about this, but leading toward the best strategy is the dolphin, right? Collaborating, trying to resolve conflict, right? Because if you hide, you can't resolve. If you get into competition, it's just a fight. Hard to resolve, right? And the zebra just accommodates. So maybe it creates peace, but how do you feel, right? If you just accommodate. So dolphin really is this idea of collaboration. So if we think of conflict resolution as a collaboration, it's really effective. So is this kind of from a teaching perspective? Okay. Yeah. So we got to this third one, right? So we talk about which animal, which one represents you, and then the most effective, we talk about the dolphin, right? Collaboration. So we don't have to watch it, but we get into some vocabulary. Good morning. We get into an interesting part here. There's a video about styles, right? Because sometimes, as you mentioned, sometimes maybe avoiding is okay, right? There are some advantages to avoiding because if you avoid it, it doesn't blow up, right? So there's a video that talks about the advantages and disadvantages of different kinds of conflict styles. And so the students predict, we do the predicting again. So what are the benefits of avoiding conflict? We said it can keep arguments from happening, yes? It can help maintain peaceful relationships, and it gives people time to think about their feelings. So in this case, A, B, and C, so you choose all, right? But the disadvantages, right? So, and a lot of these, not all, but many of them, all the answers are correct or two of the answers are correct. But it's getting you to think, oh yeah, so there are some advantages of each kind, but also disadvantages, right? So we kind of go through and talk about what are the advantages and disadvantages of each kind, okay? I don't know if we need to go through this in depth right now, but just to kind of get a sense of how this unit works. And then after they predict, then they watch the video, and then the video talks about each style. And the video also has one other style called compromising. So they have 5 styles in the video. Okay, we talked about 4 styles before, but in the video actually talks about 5. I don't think we need to go through it unless you want to. Should we? I'm just looking at, let's see, we have 10. It might be interesting. Why don't we watch the video? Because I think it's helpful to think about, like, what are the pros and cons. We don't have to go through all the predicting, but we can go through the video, okay? So let's watch that. So, okay. I think it's an interesting video. All right. So essentially, while the students are listening to this, they're checking their answers to the questions. But I really like this video because it doesn't say, even though we may say collaboration is the most effective, it sort of talks about each one because we all have our own style, right? And the nice thing is it's not saying that if you avoid, it's 100% wrong, right? It helps maintain peace. It gives people time. So there are advantages to avoiding, maybe in certain situations. But we want to kind of get toward the idea that collaboration, especially when there's conflict, is probably going to be the most effective, okay? And so that leads us kind of from learning about the different styles to a reading, and the reading kind of goes through strategies, like it's almost like a formula for how to deal with conflict effectively. So we don't have to go through it in depth, but it goes through different stages. The first one is listen actively. Because sometimes when a person is upset, what do? Like, I can't believe you did that. What do you want to do? You want to,
Try to sympathize.
you may want to sympathize, but some people may be, if I'm angry, they may get angry also. So the first thing we want to do is we always want to listen actively. When someone has an issue or a problem or there's a conflict, first thing we do is we listen. We don't speak, we listen. And don't judge or react. Sometimes when a person says something, you think, oh my God, you're so wrong, or you're crazy. But instead of that, we don't judge, right? Because one of the things about emotions is how a person feels is real for that person, regardless of what you think. So we want to, so this is again, if there's a conflict, first thing is listen. Don't judge or react. So give the person a chance to talk. And then we talked before about acknowledging, empathizing. So we acknowledge or mirror the person's feelings. Do you know what that means? Like mirror? What does it mean to mirror? Uh-huh. And when you mirror, it's like a reflection, right? So if I mirror you, if you say, I'm really upset about something, you can mirror by saying, oh, I understand that you're upset. I'm mirroring you, right? Or I hear that you're angry that I didn't take the trash out this morning. Right? So we acknowledge, and then we empathize. And that's the big one, is empathizing. Empathizing means I understand how you feel. I would feel the same way. And then we reassure. So this is really helpful. This is sort of a guide. First listen. So maintain eye contact. Don't look at your phone. Don't interrupt. Just listen. Don't judge or react. Try to see the situation from the other person's perspective. We often look at it from our perspective, but try to see it from their perspective. And then acknowledge them. I can see that you're upset. I hear that you're angry. I'm acknowledging, right? I recognize it. And then empathize. That's the big one. A great way to say it, and I do this sometimes too. I just automatically say, oh, if I were in that situation, I would feel the same way, right? It lets you know that, oh, I really understand. Or I can totally see why you're feeling this way, right? So it really empathize. And then reassure the person, I'm really glad you told me. Or it's great that you shared this with me. I want you to know that you're always welcome to let me know if something's bothering you. So let them know it's good that they told you, right? And let's work together to resolve this issue, or let's see if we can find a solution. I had an interesting thing. I was doing training in India for entrepreneurs and young business people. And one class we did this in class. The next training, there was a conflict in the group. There were two people and they started arguing in class, like very angry. And so I brought them to the front of the room and I put the slide up and I said, let's go through this. And they started yelling. I said, no. Listen, just listen. Listen, okay. And then tell the person, I can see that you're upset. And then, well, if that happened to me, I would probably, so they went through this, and then at the end they hugged. They resolved the conflict in really short time. And they were one of them was very angry, like there was a lot of tension. And so, but it was hard, like they didn't want to. Like the person, no, he did this. I said, no, just listen, like sit back. And it was very interesting to see this in real life because it was a real situation. But a lot of times when people are upset, They want to know that you understand that they're upset and that you acknowledge it and that you would probably be upset too. And then the tension just goes shh. It's amazing. So this is a really good general formula to use. And sometimes it's hard because we're human. And humans have emotions, so sometimes we tend, like if someone gets angry at me, I get defensive. Oh, I didn't mean it that way, and then right? We tend to do that naturally as humans. But if we can follow this, it's amazing how it can help with conflict. So this is a really good thing for students to sort of get the idea that here's a process, and then what we do is we do role plays. We just do some role plays where maybe we can try this. Simple. One person is an employee and one person is the boss. And then the employee's here unhappy, angry, frustrated, something. So someone's upset, and how do you deal with it? Okay? So what you can do is use the table to kind of practice this, okay? So since in your book it's on page 50, the table and there are actually 4 scenarios. The 4th one is on the next page and it's longer. But we have basically, it's always employee, boss, conflict, and how do you solve it? So 1, 2, 1, 2, 1, 2, and one person can do with me. So let's do this. Let me put you in pairs. So 2, 2, 2, 2.
All right.
You can practice with me. What I want you to do is one of you is the employee and one of you is the boss. And kind of just go through it. So read your part. And if you're the employee and you're upset, be upset. Like, I'm really upset. And then if you're the boss, wait. Okay, you two can work together and you two work together. So decide one of you is employee, one of you is the boss. And then use the structure here to go through the process. And just see, it doesn't have to be long. Just see how it feels as you're doing it, okay?
In this we start on the situation or the situation is going on.
Start with one, maybe do 2. So maybe one situation you can be the employee, and then the next time you can be the boss. But there are 4 here, so you can choose which one you want to do. So you're coming to the viewpoint of like, it's hot, it's uncomfortable. Yeah, if you have that feeling and you can't, because what part of this is stepping back, right? Okay, I'm going to listen to you. I'm going to focus on you. I'm hot and uncomfortable, but I'm going to focus on you and understand what's going on with you. We can still resolve. Maybe it's more challenging than if it's air conditioned. But part of it comes from ourself, right? Because if there's conflict and it's hot and uncomfortable, I might get into competition. I want to win this. I might get, but if I can step back and listen and acknowledge and understand and empathize and try to resolve, I can do it in any condition. It's just more challenging if it's hot and uncomfortable. Does that make sense? Yeah. So instead of saying, I'm hot and uncomfortable too, and it's like, okay, yeah, I understand how you feel, because I'm feeling that way too. Right? So we can, but we have to be, if we want to resolve conflict, we have to be the one that steps back and listens and sort of gets away from the, I just want to fight. I just want to leave, right? I want to go home and sit in my air-conditioned car. Okay, but good point. Good point. Environment can play a role. Yeah. And sometimes conflict happens as a result of environment, right? If I'm hot and uncomfortable and tired, I'm going to be angry faster than if I'm in a comfortable chair in an air-conditioned room, right? But if I can recognize that, it's like, oh, I'm upset, I'm hot, but I want to resolve the conflict, then I need to think about those things. Good point, though. Cool. Any questions or comments? Okay. Should we go to the next one? So we've kind of focused on soft skills up until now. And soft skills, as we talked about yesterday, the soft skills are important in any profession, but especially as in the field of law, having good soft skills like presentation skills. We haven't talked about presentations yet, but we will. But being able to resolve conflict, negotiation skills, things like that are going to be very helpful. Debate skills in the real world. Okay. Now we're going to get into some units on law topics, okay? And the first one is criminal procedure. Let's see. And this is kind of fun. This is another predicting activity, okay? So there are questions that talk about criminal procedure in the US and Vietnam. There's some similarities and some differences about criminal procedure in the US and Vietnam. So the students start out by predicting. Okay, so it's the same, we did predictions yesterday, same idea, but this time they're predicting just yes or no. It's like true or false. In the US, the death penalty is legal in all 50 states, though it is rarely implemented. What do you think? True or false? Okay, but students are doing this in pairs or groups, so they're just saying, maybe they don't know. So they're just guessing. So we kind of go through the same thing. In both Vietnam and the US, judges play a similar role in court proceedings. Okay, you're like, no, false. Okay. Some of you know more, right? Because, but the students may not, right? So anyway, so they're going through, they're guessing, okay? And then what we do is we do the reading relay again. So we don't have to go through this today because we did this yesterday. But it's the same idea where we work in teams. So first we try to guess. Then the teacher goes through and says, number one, how many of you think yes? How many think no? We can do this for fun just to see. So we already did the first two. How about number three? In the US, a defendant must remain in jail for several days after posting bail. Who thinks true? Some of you who thinks false. Okay, so we kind of go through.
I have no idea.
Right, so the students are just guessing though, right? It's okay if you have no idea. It's like, I think yes. Okay, we're just predicting. The thing about predictions is it doesn't matter if you're right or wrong. We're just predicting. And so in Vietnam, the prosecutors often link to the police and other state agencies. Who thinks true? False, right? We go through. Okay? Then, after we guess, then they're going to do the reading relay and run to the wall like we did yesterday. And oh, wait, let's see. Here it is. So the article is in here. So then they talk about the similarities. This is what they're reading, and the differences. Okay? So it's kind of fun. So the students interact, and then finally we can read it later, but so we do the same thing we did yesterday with the reading relay. Okay? And so it's like the role of the prosecutor is different. There's some differences. Or the use of bail, right? Or the use of juries, okay? And so there are some differences in Vietnam and the US, okay? So anyway, so that's kind of how this unit, yes?
I wonder if we will have to teach the vocabulary before we let the student do the essay.
That's a good question, yeah. Let's see if we have any, okay, detailed reading. Yeah, you might have to go through some of the vocabulary with them, potentially, if they don't know yet. Like they may not know what bail is yet. So part of it is as a teacher is sort of understanding when you go through these, you could also say, what vocabulary don't you know? Like is because they're going through predicting. So like in number 3, bail. They may not know. Okay? Or appeal, they may not know. So if they don't know, maybe you go through some of the vocabulary with them first. And it kind of depends on who your students are and what their background is. So sometimes as a teacher, we need to say, okay, is this new vocabulary or do my students maybe know this already? But you're right, you may need to go through some of the vocabulary, potentially. And in a lot of the book, oftentimes there's vocabulary before something, but not every time. So this time we don't have vocabulary beforehand. So maybe good to go through that. Okay.
Like in number 9 of the bargain, for example,
Mm-hmm.
the bargain, even the teacher will not understand it.
Okay. Okay.
That's for example.
Mm-hmm.
I think it would be better if we have a reading
Vocabulary?
vocabulary.
Okay. Yeah, maybe I can add that. Maybe I can add that here. Yeah. Part of going through the book too is to see maybe, because a lot of times I have like pre-reading vocabulary, but maybe sometimes I didn't. And maybe here, especially because this is our first unit on law. So maybe we should start it with a vocabulary exercise and then do it. So yeah, maybe I can add that here before we do the final book. Okay. Yeah. Good point. Okay. So I'll make a note and do some vocabulary for this one.
Yes, and I wonder why don't you mention the civil procedure and you go into the criminal procedure?
The civil procedure is next. The next, so it's criminal procedure and then a mock trial and then civil procedure and a mock trial. So we cover both.
Is it better if we have like some unit on criminal, on yeah, on criminal issues and then criminal procedure? Yeah, because we have civil issue and civil procedure, criminal
Mm.
issues, criminal procedure.
Yeah, I mean that's a possibility. Let me see what else we have in here. I'm trying to. What you do have, I mean, if we go through let's kind of go through the unit and then maybe talk about that. we can kind of see how the unit builds. So the first part, yeah, I agree with you. I think we should start with some vocabulary. And then we kind of talk about criminal procedure. Okay. Then on page 56, we get into the jury system. Okay. And so and the jury system in the US is being used less and less. So we'll do a listening, but we do the same thing. We predict, and then we watch a video on the jury system. So the same kind of idea about predicting and then the listening. And then on page 58, we get into kind of the stages of procedure. So some basic stages. So a lot of vocabulary comes here, but investigation, address, booking, charging, arraignment, discovery, pre-trial motions, trials, sentencing, appeals. So there's a lot of vocabulary here on the different stages. And they do this as a matching, so they match the word with the definition. And then there's an example on page 59. There's a situation. And we can look at that maybe together on page 59. In a quiet neighborhood, a 20-year-old woman named Sarah was found murdered in her apartment by strangulation. The police received a call from Sarah's roommate, who discovered her body. The investigation into Sarah's death resulted in the arrest of her ex-boyfriend, David, who had a history of domestic violence. And then you go through the stages. So investigation, the police conducted an investigation into Sarah's murder, collecting evidence, including fingerprints in Sarah's apartment. Okay. And interviewing witnesses. Arrest. Based on the evidence, the police arrested David. So it kind of goes through step by step with an example. So when we talk about the procedure, what does it look like in a real situation? Okay. And then there are some questions that they can discuss. And then there's a case study on page 60. So we have a case study. And then this is a pretty long unit, actually. And then on page 61, there's talking about prosecutors in the US and Vietnam. So we said there's some differences. This gets into a little more depth. And so they read and answer questions. The same thing, predicting, and then reading and finding the answers. So this unit has quite a bit. It has case studies, it has listening, it has reading relay, and different things. So I think what you're saying is maybe we definitely should add vocabulary here. This unit is already pretty long. It has quite a bit in it. So I would hesitate to make it too much longer because this is one of the biggest units in the whole book, is on criminal procedure. So what were you saying? That you would like to have something that talks about what types of criminal law, like criminal crimes, or what were you saying? Okay, so I understand what you're saying and the challenges. About a year ago, I did a needs analysis. Here, University of Law, I did it in Hanoi at 2 universities. And every university that I interviewed professors and English faculty and students. And overwhelmingly, the 2 most important topics that they wanted in this book was criminal law, criminal procedure, and civil procedure. Yeah, but even here, so it was about a year ago when I met with faculty here and things. The so criminal procedure was I based this book on a very in-depth needs analysis at 4 universities. So that's at this point, we can't really take out a unit and replace it because I don't have time to write another unit. But this was actually based on a needs analysis. So my needs analysis, what I found is that the big things that came up were soft skills, criminal law, criminal procedure, civil procedure. Those were the 3 biggest areas that said everybody I talked to, everybody brought up those topics as the most important. That's why criminal procedure is such a big unit here and I understand if your background is English teaching, some of this stuff might be challenging. I totally understand it because you're not a lawyer, so it's like, oh my God. But the units are designed in a way that even if don't have a law background, it's done in a way that's, because you're teaching, it's done in a way that flows really nicely and probably should give you enough information. But I agree with you, for example, maybe in some places we need more vocabulary. So I can add the vocabulary here. And then in terms of other law, international law was mentioned, business law was mentioned, but really the 2 big ones were civil and criminal. And so that's why we have a big focus on those 2 in the book. Okay? But I hear you, and I understand the challenges of even like the Hanoi University of Law, Hanoi Law University, they have a legal English degree, sort of like here, the University of Ho Chi Minh City University of Law also has a degree so students can study legal English as their major. Even those faculty, where they still struggle because oftentimes English faculty are teaching legal English. And so it's challenging because if you don't have a legal background, a lot of the terminology is going to be unfamiliar and complicated. And so part of it is, as a teacher, is also learning, right? How do you teach? Like, I'm not a lawyer, right? My background is English teaching and international business. So for me, personally, negotiations and conflict resolution, for me, that's easier than law, okay? So I wrote this as a non-lawyer, specifically for English teachers to be able to teach it. But I understand it still can be challenging. The other thing is something that you'll find as a teacher. The first time that you teach with this book will probably be the most challenging time. And then when you teach it the second time, it will be easier, and you'll get more familiar and more comfortable with it. And so my experience is that when you teach something new for the first time, there will be challenges, but you can improve as you teach, and it will get easier. The other thing is, you have a lot of resources on campus. So if you look ahead and think, oh my God, criminal law, maybe you talk to some of your colleagues and say, can you help me understand this a little bit better? So that you learn more about criminal procedure, so that when you teach it, you feel more comfortable with it. like I said, for me, business topics are really, I'd say I can teach them in my sleep, like negotiations, presentations. I've been doing that for 25 years, so it's really easy for me. Law is more difficult, but this book is designed to be teacher friendly. In most cases, it's not designed to make it difficult for the teacher. It's really very student-centered. If you look at the activities, a lot of times the students are discussing and the students are finding the information, right? It's not that you're lecturing about law, it's the students are doing a reading relay and finding answers and then doing detailed reading. And so they're doing a lot of the work. You're more the facilitator who's guiding them through the process, okay? So don't panic. Don't panic. It'll be okay. Okay. So where were we? Yeah. So as I mentioned, criminal procedure has a lot of content. There's a lot of information, but it's very engaging and very interactive, and a lot of predicting and students working together, making predictions, either reading or listening to find the answers. And actually, some of the things that you were asking about with vocabulary, like in part D on page 57, number 6 says, what is a plea bargain? So some of the vocabulary pops up here. So you mentioned plea bargain might be a difficult term for students, but it does come up. It does come up in the unit. Yeah, and summary judgment also comes up as a word. But yeah, so maybe I still can add a one page on pre-vocabulary for the reading, but we do have some of it coming up again later. And then, like I said, page 58 is all vocabulary about appeals and booking and address. So we have a lot of vocabulary in the unit, actually. Okay. And then the last reading on prosecutors is someone requested this actually about having a little more on the difference between US and Vietnam, so I added that. Yeah, I mean, you can definitely recommend students watch it. It's about 12 Angry Men. Because the jury has 12 people, so it has a lot to do with the jury. So it's an interesting movie to watch. Yeah. Okay. Good. Anyway, we went through this quickly. The video on the jury system in the US is really interesting because in the US, in the past, juries were really common. But today, many cases are resolved through plea bargains, where a person says they plead guilty to something lower. So that saves a lot of money and time. It's like, okay, instead of 10 years in prison, maybe you just pay a fine, but you still, so it means that juries are used less and less these days than they used to be, okay? Even though technically in the US you have the right to a trial by jury, Um, a lot, yeah. Even simple things like if you drive too fast, speeding ticket, okay? If you go to court, sometimes before they'll say, okay, we're going to give you, we'll just say you did something lower, you still pay money, but you don't have to go through the whole trial. And it's most people do that. It's very common. Because if I'm speeding, I know that I was speeding, but maybe I think, well, okay, I'll plead guilty. It's a simple crime. I plead guilty to something less, then I don't pay as much money and I'm done. So a lot of times it's very simple to do that. Okay? Oh, committing crimes. Yeah, so yeah, I mean your traffic violations go in, but it's not like it doesn't go into usually after a couple years it's removed. They remove it. So it's not like a major crime. If you speed, it won't affect your ability to get a job. But if you rob somebody, or you kill somebody, or you beat somebody, then that's going to be in your permanent record, usually. So traffic crimes are kind of minor, usually, unless you do something like driving drunk, or something like that where it's more serious. But speeding tickets are more, yeah, they're more minor, very minor, and not permanent. So after a certain number of years, it disappears. Okay. Cool. Anything else? I was going to ask a question. How many of you teach English? How many of you teach English in here? All of you teach English? Okay, because I know we had some people who were here yesterday who also teach law. I teach law in English, but how many of you would likely teach legal English? So you would probably teach, would you teach legal English? Yeah, you would teach it. Okay. Yeah. Yeah, it's different. Teaching law in English and teaching legal English is different, right? But what's that? Yeah. Okay. Cool. So let's look at okay. Let's go to page 64. So unit 6 is fun because you do a mock trial. Okay? This is kind of, the big thing here is setting it up. How do you set it up? But you can create a trial where students all play different roles. So you have a judge, you have a prosecutor, you have attorney, you have defendant, you have witnesses. So you create a whole court scene where the students can actually act it out. Okay? So if you look at page 64, we talk about different roles in the courtroom, and that's another matching activity. Okay? The judge, the jury, the prosecutor, defendant. Bailiff might be a new word. Do you know the word bailiff? This is page 64. Do you know the word bailiff? What's a bailiff? Mm-hmm. Mm-hmm. Oh, okay. A bailiff. Okay. Yeah, in the U.S., a bailiff is more like someone who keeps order, right? They keep order in the court, and they make sure everybody's safe. So the bailiff is like an officer, more. Yeah. So in our definitions, the bailiff is C, a court official responsible for maintaining order in the courtroom and ensuring the safety of all present. So the bailiff, that's their responsibility. So it's different than Vietnam. That might be the hardest one here. Court reporter, witnesses, and then the court interpreter, if they have one, is the person who translates if needed. So for example, if you're in the US and you don't speak much English, maybe you have an interpreter to help you. Welcome back. I thought you left us. She's like, criminal procedure. Happy to see you again. So we're on page 64. We're talking about the mock trial. And the most difficult word is number 5, bailiff. And the answer is C. So the bailiff really is making sure that there's peace in the courtroom. Okay. And then, before we get into the trial, we do predictions. And then we're going to do a listening activity. So we have some questions, like in the US, who decides whether a defendant is guilty in a criminal trial? The judge, the jury, or the judge and the jury together? So they're making predictions. Which of the following is true about juries? How can a jury reach a verdict of guilty or not guilty? So it gives the students a chance to kind of predict what they think. In some vocabulary, like what is an acquittal? What are deliberations? So there's some vocabulary here that comes up defined in the video. How many jurors need to agree for a defendant to be guilty? More than half, 2/3, or all of them? Do you know the answer? Any idea? Say 65, number 6. Number 6. What do you think? How many jurors need to agree for a defendant to be guilty? More than half, 2/3, or all of them? What do you think? You think 2/3? It's actually all of them. Yeah, so in the US, if you have 12 jurors and 11 say guilty and 1 says not guilty, it doesn't work. All 12 have to say guilty, right? So it's interesting. So anyway, these are good questions to learn about kind of the jury system. Who announces the verdicts to the court? The judge, one of the jurors, or the bailiff? So you may not know these. Do you want to watch the video? Yeah, why don't we watch the video? So page 65. Let's try to answer the question. So who decides? Number 2, which of the following is true about juries? So the students are predicting here first. They do the predictions. How can a jury reach a verdict? What is an acquittal? What are deliberations? How many jurors need to agree? And who announces the verdict to the court? Let's watch this because there's maybe new information for you. 66. Okay. So anyway, so this just gives a brief overview, but it's kind of fun because the students predict, and then they listen and they get the answers. Okay? So then we get into, on page 66, opening and closing arguments. So we have examples here of opening arguments and closing arguments. So the students have some guidance for how to do this. Okay? So 2 months ago, a convenience store was robbed and the clerk was murdered. Based on video surveillance footage and witness statements, Anton Baker was charged with the crime and is now in court. At the beginning of the trial, the prosecutor and defense attorney make their opening statements. So we have the opening statements, and then we have the closing argument samples. So the students get a chance to look at examples, and then they discuss like how convincing are they, and what are the keys to making arguments clear and convincing. So students kind of discuss this, they look at examples, and then they kind of discuss, so what are good opening statements? We can go through one together. Why don't we look at page 66, the opening argument of the prosecution. It says, ladies and gentlemen of the jury. And again, because the jury makes the decision, it's very common for the attorney to address the jury. Ladies and gentlemen of the jury, we are here today to seek justice for the brutal and senseless murder of an innocent store clerk and the theft of cash from the store's cash register. Our evidence will show that the defendant, Anton Baker, is guilty beyond a reasonable doubt. Surveillance video and witness statements clearly identified him as the perpetrator of this heinous crime. The prosecution will present irrefutable evidence that will leave no doubt in your minds that Anton Baker is responsible for this tragic incident. The prosecution team urges you to carefully consider the evidence and find Anton Baker guilty as charged. So it's short, but this is a good example of an opening argument. And then opening, and then the two closing arguments. So then on page 68, they watch a mock trial. This one doesn't have a jury. It's done by a group of students. So it's kind of like them. They're students. It's a group of law students. And so they watch the mock trial and they answer some questions. Like, what does the bailiff say at the beginning, just before the judge enters? Does the bailiff say, all rise? Does the bailiff say, please be seated? Or does the bailiff say, please be respectful? What does the judge say after she enters? All rise, please be seated, please be respectful. Who makes their opening statement first? The prosecution, the defense, or the jury? So we kind of go through these points so they listen and they can kind of see the structure of a mock trial. Okay? What are the main points the defense includes in the opening statement? What happens after the opening statements? So it's kind of like it's also the procedure of what's happening in the mock trial. Okay? And then, and question 12 says, how do you think the case against the defendant would have been stronger? So they ask some questions about how it could be better, because they have it's a small group, so they don't have a lot of witnesses. So it's pretty simple, but at least gives us some structure. And then the students are given roles and they prepare for a mock trial, okay? So on page 69, it says the defendant, John Smith, is charged with armed robbery, which occurred on June 1st at the First National Bank of New York. The prosecution alleges that John Smith entered the bank armed with a handgun, threatened the employees and customers, and stole over $100,000 in cash and jewelry. The defense argues that John Smith was not present at the time of the robbery and has been wrongly accused due to mistaken identity. So this is our context, our situation. And then we have our different characters. So someone's going to play the judge. Someone's going to play the defendant, that's John Smith. Someone's going to play the prosecutor. Someone's going to play the defense attorney. The jury depends on how many students you have in class, but you can make the rest of the students the jury. And then on the next page, on page 70, we have the bailiff. We have witness 1, witness 2, witness 3, and witness 4. So we have 4 witnesses. We have the judge, the bailiff, the prosecutor, the defense attorneys. So we have a certain number of people. And then there's a description of how the mock trial will run. The big thing is the students will need time to prepare. So if you're the defense attorney, you need to prepare an opening statement. You need to prepare a closing argument. If you're the judge, you have to be very clear about the process, what happens first, what happens second. But on page 70, it actually outlines, it says, the bailiff says, "All rise," as the judge enters the courtroom. The judge enters the courtroom, instructs everyone to be seated, and briefly outlines the case. The judge then asks the prosecution to make their opening statement. So it sort of gives the basic structure of how the mock trial will work. And then at the end, they debrief. Do you want to watch the mock trial? Let's watch the sample to kind of get a sense of what it might look like. Welcome. Yeah, so this video helps, right? Because this is a group of students acting out a court scene, right? It's a little bit short because they don't have a big class. So they're lacking witnesses and things like that, but at least gives a framework where you can see how the judge presides, what happens first, what happens second. The bailiff is saying, "All rise," things like that. And we get a sense of an opening statement and a closing argument. And then the students can kind of talk about it. Some of the questions here, when they watch the case, let's see. Okay. Yeah, there's some questions like, what other witness, number 11, on page 69, what other witnesses do you think the defense should have called? Because they only had one person, right? Maybe one of the family members to talk about her character, the police officer a question, or at least one of the defendant's friends who was at the party. You notice she said her friend said she drank a lot, right? So it would have been helpful to have a witness who said, "Oh, she was there the whole time." So thinking about also strategy, right? Or number 12, how do you think the case against the defendant would have been stronger? Maybe if there was video surveillance or something. So trying to get the students to think about how this is a mock trial. How could this mock trial have been better? Personally, I think that they had 2 attorneys for each side. It would have been better to have 2 more witnesses, would have been more effective as a mock trial. Because it's better to have more witnesses who can say, "Oh, I saw her, she was at the party. She passed out," right? "She didn't go anywhere." But anyway, and it would have been nice to have more students so they could have a jury, and then the jury decided. But at least it gives us a group of students, right, kind of doing this, so they could see, "Oh, okay, we get an example." So for their mock trial, they'll have more roles to play. And if you have a larger class, you could, for example, pick teams. Like you 2 are going to be the defense attorneys, and you 2 are going to be the prosecution, kind of like they did here. Because that way, maybe one of you makes the opening argument, one makes the closing. So you can kind of work with that, depending how many students you have. Someone who's maybe a weaker student could be on the jury, or could be the bailiff, because the bailiff just says things like, "All rise." It's a more simple role. The judge, the most difficult roles are the judge, the prosecutor, and the defense attorney. Those are the most challenging roles for this. But yeah, it's something that's really fun to do. And what questions do you have about mock trials? Yes?
I'm just curious whether the military court, the same procedure, like in the movie A Few Good Men with David Moore and Tom Cruise.
Ah,
It's kind of military part. And I have never watched anything with the criminal procedure.
okay.
So I just wonder whether they are just
Yeah, military court is a little bit different. I'm not an expert on military court, but yeah, military court, it's has some similarities, maybe a little different. But you recommended 12 Angry Men, right? That's a criminal court. So watch the movie 12 Angry Men. That would be a good one to see, maybe a movie with a criminal court.
but in every court, even civil, criminal, they will say, the bailiff will say, all right, right?
Civil court, I'm trying to think in a civil court case if the bailiff says all rise. Civil court and criminal court are a little bit different. So I would say for the purpose of teaching, maybe focus on just the bailiff at criminal court and keep it simple.
Yeah, because I also from the movie, you see that some courts for maintenance rights, for example, there's no like advocacy at all. It's just the church and the people. So it's a kind of different kind of court.
Yeah, maybe it depends on, I mean, movies, the thing about movies is movies are not necessarily 100% real, right? So what might be interesting for you to do is maybe to go online and see if you can find it televised, because sometimes if it's a big trial, they'll have it on TV. You can actually watch a criminal court, like a real one, as opposed to a movie, might be helpful.
Is it any official channel for
I would go into YouTube. I would go into YouTube and then maybe the one thing is usually if a criminal case is televised, it's usually a very big case, like high profile. Because most of them aren't, you can't actually see it. But if it's a big, like sometimes high profile cases, I think the OJ, do you know OJ Simpson? He was an American football player who was accused of killing his ex-wife and her boyfriend. And it went to criminal court. That one I think was televised. And that might be interesting to see because you can actually see the trial. In criminal trial, he was not guilty. But in civil case, he was guilty. So in a criminal trial, the difference is in a criminal trial, you have to prove guilty beyond a reasonable doubt. So you might think, oh, there's a lot of evidence, but I'm not, it has to be almost 100% sure. And so someone being guilty in a criminal trial is more difficult. In a civil trial, it's they call it preponderance of evidence. It means you're more than 50% sure that the person is guilty, responsible. So a lot of times, like Donald Trump right now, the state of New York is suing Donald Trump in civil court because it's easier. It's easier to win in civil court than in criminal court. And so O.J. Simpson, that's why in the criminal court, even though there was a lot of evidence, there was enough doubt because if there's some doubt, if there's some uncertainty, the jury will say, well, it's not, we're not so sure. But in civil court, it was clear that in civil court, it was much easier for him to be guilty. And so he had to pay a lot of money. And so that's why sometimes people decide whether they want to go to criminal court or civil court for certain cases. Because in a civil court, you're usually suing for money. Okay? But in a criminal court, he would go to jail for many, many years, or maybe for life. And so to prove him guilty is much more challenging. But in civil court, okay, there's enough evidence to say, I think you're probably guilty, so you have to pay a lot of money. Does that make sense?
I know that you're not a lawyer, but can you just try to give me some of your thought about the reason what's the purpose of bail in criminal cases? People pay a lot
Of bail? Yeah. So bail, the thing with bail is if you can't put everybody into jail before they go to trial. So sometimes you can, but the thing with bail is a way to, so let's say you're accused of murder. Now let's do something easy. Let's say you're accused of stealing money. Okay? You're accused of stealing money from me. I believe you stole 1 million Vietnamese dong. No. There's evidence that maybe you stole money. Let's say I have a store and we think that there's enough evidence that you probably robbed my store. Okay? And so instead of putting you into jail until the trial, you do what's called posting bail. It's like a guarantee that you're not going to run away or leave the country or something. And so bail is a way to, you don't have to go to jail yet, but it's like a guarantee. So if you've run away, then that money is kept. If you did something really bad, like you murdered somebody, they might keep you in jail until the trial because they might think you're dangerous. And so, or they might think you're called what's a flight risk. A flight risk is they think somebody might leave the country to try to avoid. And so certain people they keep in jail until the trial, but most people post bail, which means that they can stay out of jail until the trial. Does that make sense?
Yes, so that's kind of unfair for the people who do not have money.
Well, posting bail, sometimes we can do a little, maybe I can give you more information on bail. When you post bail, it doesn't necessarily mean that you have to have the money, but you have to get the money from somewhere. I can explain a little more later, but so if I'm poor and I don't have money and they want, my bail is $1 million, I can't post it. I don't have that money, but maybe there's a way it works like a company or an organization can post bail for me. But I'll give you more information about that later. I think we break for lunch now. So are we doing the same as yesterday? Come back at 1:30? Is that good? Okay. And then after lunch, we'll get into civil procedure. And then we'll talk a little bit about international law and contract law and business law. Okay? So I know a couple of you weren't here this morning, but this morning we did criminal procedure. So now we're moving into civil. And so it starts out with a comparison of criminal law and civil law. So at the beginning, the students discuss what they think. What do you think? What's the biggest difference between criminal law and civil law? What's the biggest difference? We're on page, what are we on? Page 71, I think? 71, yeah. What's the biggest difference between criminal law and civil law? Is what?
If the one in the criminal court, they guilty, you go to jail.
Yeah.
But in civil, it's mostly about money, about friendship.
Excellent. Yeah. So in criminal law, very often if the person's guilty, they'll go to jail. But in civil law, it's oftentimes about money. So good. Excellent. So which one is usually considered more serious?
Criminal law.
Criminal law is usually considered more serious, right? Good. Okay. So this starts out with a, oh wait, hang on. This starts out with some vocabulary. And this vocabulary relates to a video we're going to watch. Okay. So this is good. So we have some vocabulary like the word plaintiff, defendant. Have you heard preponderance of evidence before? So in criminal law, we say a person must be guilty beyond a reasonable doubt. In civil law, we say a person is guilty. We use a preponderance of evidence. What does that mean? Do you have any idea?
Based on the should be mostly the evidence enough to have conclusion that it's one.
Yeah, actually, it's A. It's more than 50%. That's why civil cases are easier to win. You just have to show that if you weigh most of the evidence is in your favor, more than 50%, then it's okay. That's called preponderance of evidence. Okay. And you say the next one says guilty beyond a reasonable doubt. That means what? It's not 100%. Usually it means, see, there's no other reasonable explanation based on the evidence. So if someone's guilty in criminal law, it's not 100%, but it's almost. So it's sort of like there's no other reasonable explanation. So you're almost completely certain. Okay? Yeah. And then we have sanctions. What are sanctions? Sanctions are specific sanctions that included fines were placed on the company because of the crime it committed. Kind of penalty, yeah. Sanction is a kind of penalty. Then we have remedies, injunction. What's an injunction? A, ordered by the court in a civil trial to either do or not do something is an injunction. Yeah. Incarceration. Imprisonment, incarceration. So these are kind of some higher, more difficult words, right? Incarceration. Yeah. But what was the result? Who won? Pepsi won the case, yeah. Interesting, right? Deception. Yeah, it can be. So the thing is that it's deceptive on one hand, but they were able to prove that it was kind of a joke. And then there were enough laws that supported what they did. Like there's a law in New York that says if something is worth more than $500, you have to have a contract in writing. So they were able to use the laws to win the case. Even though this guy won. I mean, he basically got, he had friends who gave him money and helped him. So he actually fulfilled what they said, right? And so I think it's interesting that he lost. Because really, because they have like the sunglasses and the leather jacket, and those are real, right? And then suddenly the Harrier jet, but because the Harrier jet is worth $24 million, then it's so much higher than how much he spent $700,000 or whatever the points. But it's still interesting, right? But I think it's a fun case to use. And then at the end, the students discuss, do you agree with the court's decision? Do you agree? And students can discuss this. And when I say, no, right? You said it's false advertising. They should be responsible because they advertised it and he followed what they said. He actually played by the rules, right? Because Pepsi said you can buy points. So he bought enough points. So technically, he followed their rules, right? So, but the other thing, Pepsi's a big company. They have a lot of money. They probably have really good lawyers, right? And so it's an interesting case. It's fun because the students can discuss it. What do you think would have been the fairest outcome?
I think they should have responsibility for their advertisement because they do something.
Yeah. But they changed it. They changed it after the case. They changed the advertisement. But anyway, this is something that students can discuss, right? Obviously, it's a fun case. You think, oh, because it's exciting, right? That a person thought, oh, I'm going to get the jet, and he actually did everything. So it's a fun case to discuss. And then, they can talk about what they learned from the case. They can apply it to their own career. So it's kind of a fun case about, talking about using existing laws and how you can do things with it. Fun, right? I like this one of my favorites. Cool. So this is, again, we didn't go through everything this year, but this is kind of this sort of ending, but it's a fun way to discuss. And then we move to, we don't have to go through this in detail, but we move to mock civil trial. So kind of like we did with the other case. This time someone had an injury, so it's an injury type of thing, like an employment type thing, you got an injury. And then, we have a case. So it's kind of the same thing, we have a sample opinion argument. So similar to what we did with the criminal. So we have opening statements, and there's some questions that the students can discuss for each one, and then we get into, so there's one case that's used, the handbook is used as an example, and then this is the actual one we're going to discuss. And in this one, there was a collision between a motorcycle and a car, okay, which is typical in Vietnam, right? There's a lot of motorcycles. So this is kind of a fun case. And so the students take this case, the plaintiff wants compensation. We said the civil cases is usually about money. So this person wants $100,000. because of Las Vegas name, expenses, and things like that. And then, the participants, we have a judge, we have a jury, we have the plaintiff, the defendant, the lawyer, the defendant's lawyer, the clerk, and the witnesses. And so for the witnesses, we have different parts. This person saw the car hit the motorcycle. This is a doctor. They're going to talk about the injuries. The plaintiff's parents, they can talk about how the injury impacted the person's life. Because a lot of times they say, well, he's suffering. He was in the top crash, and the professor who can say that the defendant is a really good student, they're hardworking. Sometimes, I don't know how to think so these are defendants, and it's so it's kind of fun. And then we go to the flow, the opening statements, the case, details, and the defendant's case, and the closing arguments, very so what kind of this book has allows you to different yeah, so that's pretty much, so the flow is similar to where we go from learning about some differences and things, and then we get to okay? Questions? I know we only have a little more than an hour, so we're trying to get through the rest. Any questions on this? So maybe we can move to business law. So unit 9 on page 88 is business law. Okay. And so this one starts out with a discussion of what is business law. So the students can talk about what they think business law is and why it's important. So they kind of get into the set the context. Then we get into vocabulary. We have a lot of vocabulary here. So we have a lot of vocabulary in there. So a lot of good things, sport, liability, intellectual property, contract, arbitration. So a lot of really good vocabulary. So they match the vocabulary. Okay. And then all of this vocabulary comes from the reading. So this time they're going to move to the reading. And then they answer the questions. So, and the reading basically talks about each one of these points and some others. So it's like a preparation, and then they read about business law, and then they have some discussion questions. Okay? Then, on page 90, we get into our predictions again. This is a really cool case. This is a very famous case. It's used in a lot of law programs. It's called Solomon versus Solomon. If you go onto YouTube and you type in Solomon versus Solomon, there are lots of videos on this case. It's a very well-known case. It's a very old case. It happened in 1897 in the UK. It's a very old case. But it's an important, like one of the key important business cases in history. And so the students make predictions about Solomon versus Solomon. And we just guess it here, we don't know, right? So what do you think Mr. Solomon's profession is? A carpenter, a shoemaker, or a grocer? What do you think? Who thinks he's a carpenter? Who thinks he's a shoemaker? Who thinks he's a grocer? Okay. What are shareholders? The legal owners of the company, individuals who share the management of a corporation, or banks that provide loans to businesses. Who thinks it's A, the legal owners? Who thinks it's B, individuals who share the management? C, banks that provide. Okay. Of the company's 20,007 shares, how many shares did Mr. Solomon own? 10,000, so just over half. Almost all or all of them. Who thinks just over half? Who thinks almost all, 20,000? Who thinks all the shares? Okay? Again, we're just predicting here. What does the company went bust mean? What does that mean? The company went bust. It grew quickly and successfully. It moved to a better location, where it was forced to close because it was not making money. Who thinks A? B? C? All of you are Mexicans. What is a one-man show in business? A person who is an actor or a performer? A person who shows up for work on time? Or a person who manages everything? C. Okay. What does separate legal personality mean? Separate legal personality. A company is a distinct legal entity from its owners. A person's character can be used against them in a court of law, or an individual's position in a company is defined by legal standards. Who thinks A? Who thinks B? Who thinks C? So we have A, B, and C on this one. What is limited liability? Shareholders are only partially responsible for a company's financial issues. The maximum amount that owners can lose is what they invested, or the success of the business is limited by specific legal provisions. Who thinks A? Who thinks B? Our lawyers. Who thinks C? Okay. Number 8, when this case went to the highest court in England, what did the court decide? A, Mr. Solomon's company was a separate legal personality, so he was not personally responsible. B, Mr. Solomon's company needed to be liquidated, and the money would be used to pay the loans. Or C, Mr. Solomon's shareholders were required to repay the loans. Who thinks A? Who thinks B? Who thinks C? So we have A and B. Why did the court come to their decision? A, because Mr. Solomon was bankrupt. B, because the shareholders were responsible for the failed business. Or C, because companies exist to make business less risky. Who thinks A? Who thinks B? Got a couple of B's. How about C? Got some C's. What principle did this case uphold? Separate legal personality will be maintained even for a one-man business.
Shareholders can be equally liable for the loans they approve. Or C, the sole proprietorship has the same rights as a limited liability company. Who thinks A? B? C? Okay, so we don't know. Okay, let's watch this. I think this is a cool case, and then we'll see what the answers to these questions are.